Welcome to our webinar today, Gun Trust Update, New Rules and Regulations You Need to Know About. This is Alan Gassman, and I am very pleased to have our presenter, Sean Healy, with us today. As you're going to see, Sean is probably the leading authority in this area in the United States. So we're really glad to have him. A little bit of an advertisement here. Please tune in Saturday, November 5th. I'm going to give a little talk called Cornflakes and Estate Planning Mistakes. It's more of a layman's talk for the biggest mistakes we see in estate planning. Tuesday, November 15th, my friend David Finkel and I are going to talk about the 7 biggest mistakes that medical practices make with respect to business decision making. And we'll be again representing the cornflakes and asset protection mistakes on Saturday, November 19th. Also, just announced, and I'm really excited about this, one of my favorite authors and my favorite speaker, Srikumar Rao, and I will be speaking at Stetson Law School on Saturday, February 11th on what it takes to be a successful professional. And this is going to be a 6-hour interactive workshop. A lot of the attendees will be practicing lawyers and other professionals. Let us know if you would like to attend. It's really, really interesting to interact directly with these third-year law students and young alumni from Stetson Law School. So I hope you'll consider joining us for that. Now, to tell you a little bit about Sean Healy, I can only give you the tip of the iceberg on this extremely talented and conscientious lawyer. Besides being the general counsel for the Texas State Rifle Association, besides being a AAA arbitrator, besides having testified at legislative committees as an expert witness, he is also a concealed handgun instructor, an NRA certified instructor. He has certifications in pistol, rifle, shotgun, muzzle loading, pistol, metallic cartridge, reloading, shot shell reloading, home firearm safety, and personal protection in the office. He's a chief range safety officer and a nationally trained instructor trainer for Texas 4-H shooting sports. And as you can see from the biography, I can go on and on and on. This guy lives and breathes gun safety and gun trust law, and I was very proud to have been a co-author with him in a new gun trust book that's going to hit its 2nd edition very soon. So Sean, welcome to the webinar, and I'm going to let you take it from here.
Thank you, Alan. I appreciate it. Alan's the one that did most of the work behind the book, so he deserves a lot of the credit for that. I appreciate that introduction and all the opportunities that he's given me to get the word out on these things. I'm going to talk today about gun trusts, and that includes really 2 types of gun trusts. The first one is an NFA trust. That's a specialized type of trust designed to own firearms that are regulated by the National Firearms Act, such as short-barreled rifles and shotguns, suppressors, and machine guns. And then the other type of gun trust is a trust that's designed to own normal types of firearms like regular rifles, pistols, and shotguns. That's a growing area of the law because a lot of people are wanting to form trusts just to preserve their guns for future generations. But before we get into that, we need to ask the question, is it a good idea to allow civilians to own NFA firearms such as machine guns and suppressors? And if you go in there and dig into the numbers, you'll find that it is almost unheard of for a legally owned machine gun to be used in a crime. The statistics are up there on the chart. The bottom line is that the director of ATF told Congress in 1987 that registered machine guns which are involved in crimes are so minimal so as not to be considered a law enforcement problem. There it is from the horse's mouth. The leading regulator and law enforcement official over firearms in this country said that legally owned machine guns are not a law enforcement problem. You might also wonder if owning suppressors is a legal problem, And there are also statistics on that. There's a report that was written by an attorney who went into detail on federal and state prosecutions in that, and those are a little bit more common than crimes with machine guns, but again, they're almost unheard of. And the reason for that is pretty simple. The process that you have to go through to have one of these items registered in your name includes a background check and very strenuous standards, and if you meet those standards, you're probably not the type of person to commit a crime. So is it a good idea to allow civilians to own these items? The answer is, from law enforcement and different types of statistics, is that it's not a significant law enforcement problem. Before we get into the specifics of forming NFA trusts, I'm going to tell you 6 legal principles that will help you understand everything else that we're going to discuss today. If you understand these legal principles, then you will understand everything you need to know to competently draft a gun trust or an NFA trust. If you forget any of these principles, then you're creating potential trouble for yourself and your client. But when I got started in doing this, once I understood the basic idea, I got these principles right in my head, and then I went through the form of a living trust with trying to keep all 6 of these principles in mind at the same time, and I literally changed every sentence or word that needed to be changed to take these principles into account. And if you do that diligently, when you're finished, you'll have a good NFA trust that it is safe for your clients to use. The first principle is, with the National Firearms Act, that it is a felony for any person other than the registered owner to possess an NFA firearm. And there's a list of the items right there: machine gun, silencer or suppressor, short-barreled rifle or shotgun, destructive device, or any other weapon. The second thing is, to become the registered owner of one of those items, you have to submit a form to ATF, you have to pay the transfer tax, which is normally $200, and then you have to have that form returned to you by ATF with a tax stamp. That tax stamp indicates that the transfer has been approved, and only at that point can you take possession of that NFA firearm. As we'll talk about in a little bit, the regulation that became effective in July also requires information on responsible persons, and for a trust, those are the persons that either have the right to possess the NFA firearms or have the right to make significant decisions regarding the trust. That's the same definition of responsible person applies to corporations and business entities who are also allowed to own NFA firearms. Number 3 principle is that the federal tax code includes the National Firearms Act. This is actually a tax law. It's not a law regulating interstate commerce. The authority for this law comes from Congress's ability to tax, not its ability to regulate interstate commerce. And because of that, the definitions in the tax code apply. The definition of person includes trusts, corporations, and other entities. So it's a matter of federal statute that NFA trusts and NFA corporations and other entities are authorized by federal law. It's in the tax code. The 4th principle applies not only to NFA firearms, but also applies to normal firearms such as rifles, pistols, and shotguns. And that principle is that any prohibited person is prohibited by law from possessing a firearm or ammunition. And that's generally for life unless they get a pardon or some sort of restoration of rights. So a convicted felon is the most obvious example of a prohibited person. It also includes illegal aliens, persons who have renounced their citizenship, fugitives from justice, persons with dishonorable discharges, persons who have been adjudicated mentally defective or involuntarily committed to a mental institution, persons who have been convicted of misdemeanor crimes of domestic violence, persons who are subject to protective orders and similar orders. Those are the categories of person, and it's also illegal for any person who's been charged with, who is currently charged with a felony to possess a firearm. So if you fall under one of those categories, you're not allowed to possess a firearm or ammunition. If one of your trustees falls under that category, then you really don't need to have them be a trustee of a gun trust. If one of your beneficiaries falls under that category, then your trust needs to make arrangements to sell the item and distribute the money to that beneficiary, or to distribute the property to other persons, so that you never put a prohibited person in possession of a gun. The fifth principle is that every state has its own laws that govern NFA firearms, and actually normal firearms also. So to stay out of trouble, you and your clients need to comply with federal law and with state law. And then finally, the normal requirements for a valid trust, for creation of a valid trust, and for a trust to remain valid apply. So, for instance, in Texas, we have a merger doctrine that says that if the same person is the trustee and the beneficiary, then you don't have a trust, and that person just owns the property. That would be the desired result in regard to financial assets, because there's no reason to tie that person's hands if that person's also the beneficiary. But when you're dealing with firearms that have to be registered under the name of a specific person or entity, you've just made that person into a felony if they're in possession of it, but if it's registered in the name of a non-existent trust. So your trust has to be valid when it's formed, and it also has to remain valid without interruption during the entire time that it owns and possesses NFA firearms. Those are the 6 legal principles that apply to this operation, the creation and operation of NFA trusts and gun trusts. And you need to keep all of those in mind at the same time whenever you're dealing with NFA trusts. Here's a list of NFA firearms that we've already gone over. A machine gun is any firearm that fires more than 1 bullet per pull of the trigger. A suppressor or silencer is any device that's attached to a gun to muffle or suppress the sound. A short-barreled rifle is any rifle with a barrel that's less than 16 inches. Short-barreled shotgun is any shotgun with a barrel of less than 18 inches. And destructive devices include things like bazookas and cannons and grenades and things like that. And then any other weapon is a category that includes some collector's item type things like guns that can be encased in a briefcase and be fired from within that briefcase, and cane guns and combination knives and handguns and things like that. Texas law has some examples of prohibited weapons here. The first 4 categories parallel the National Firearms Act categories: explosive weapons, machine guns, short-barrel firearms, and firearm silencers. And this actually, switchblade knives, that's been changed under Texas law. That's not illegal anymore. But brass knuckles, armor-piercing ammunition, chemical dispensive devices, and tire deflation devices are not regulated by the NFA. So this is an example of a state statute which kind of parallels the federal statute, but it's not identical. And of course, you and your clients have to comply with both. This is a chart which is in the paper that you can use to identify which law applies to your firearm. And the definitions in the National Firearms Act are the ones on the top. The definitions under the Gun Control Act are the ones on the bottom, but most of the time, if you have an NFA firearm, both laws are going to apply. There are some items that are firearms under the NFA but not Gun Control Act, and that means the exotic ones, machine guns and things like that. There are some guns in the upper right category that are only firearms under the NFA, but they're not actually guns, so they're not covered by the Gun Control Act. And that includes silencers, parts for suppressors and machine guns, and then destructive devices that are not firearms. Those are NFA firearms, but they're not Gun Control Act firearms. So the NFA would apply, not the Gun Control Act. The lower left category is firearms only under the Gun Control Act, and that's basically normal guns that are not exotic. And then finally, the lower right category includes things that are not firearms under either law, and that includes antique firearms like black powder guns, some of them anyway, air guns, and then certain devices that the Secretary has said is not likely to be used as a weapon. There's the list of prohibited persons. I'm not going to go over that again. You can see that in the paper. Here's other prohibited actions that are important. If you're under indictment for felonies, you can possess them, but you can't ship, transport, or receive them. Persons under 18 can't have handguns or handgun ammo. It's not considered a conviction if it's been removed under state law or the rights have been restored. And then finally, the big one is that if you sell or dispose of a gun or ammunition, knowing or having reasonable cause to believe the person is a prohibited person, then you're committing a felony also. This is an example of ATF Form 4, which is to transfer an NFA firearm. A lot of times a dealer is the one that fills this out for you, but this is a form that you use to acquire an NFA firearm most of the time. This is the new form that has the responsible person information in there that you now have to provide after July. This is some basic information on a trust. You can go through this on your own. Just make sure under state law that your trust is valid, it remains valid, and then you'll want to tailor the provisions probably to put your person more in charge, because the intent of this trust is not so much to get another responsible person to make decisions, it's to authorize additional persons to possess the NFA firearms. That's the easiest way to allow a relative or a friend access to these, or if you have someone who lives with you, like your wife, that you don't want to be at risk for a prosecution because they're going to have access to that firearm, you put them on the trust as a trustee and they're authorized to have it. Generally, the powers of trustees are broad because we choose people that our clients trust to be trustees. So when you give somebody the power to possess a machine gun or something, you're in a sense you're putting your life in their hand. And this paragraph right here is the kind of catch-all provision for the powers of trustee under Texas law. It basically says that that person can pretty much do anything with a trust property that they could do with their own property. So that's a lot of power to put in somebody's hands. You want to make sure that person is very responsible, very safe, and very trustworthy. Here are some of the features of NFA trusts. You need to thoroughly consult with a client and make sure that you have a good understanding of their knowledge of guns, gun safety, and gun laws. I start with a standard living trust form, and I use a revocable trust in almost every circumstance. You need to make sure the trust begins being a valid trust and remains valid. You want to check the client's estate plan to make sure there's no conflicts. You want to spend a lot of time and effort educating your client and the trustees about the legal requirements, not only of keeping a trust in play, but also of complying with the gun laws. And then finally, since your client is probably the one who paid for the trust and purchased the NFA firearms, you want to give that person powers that override the other trustees' powers. You wouldn't want to appoint your client's uncle as a trustee and then have your client call you in a month and say, my uncle sold my $20,000 machine gun, what can I do? So a lot of times you want to have different classes of trustees or some sort of provision that allows your client to override the other trustees and limits their power to do things that your client wouldn't want done with the property that he paid for. You want to minimize civil liability. You don't have limited liability like a corporation, but you still want to be aware of the fact that this is an inherently dangerous activity and try to protect your client as much as possible. I like to include an arbitration clause in there to keep any disputes with the trustees or beneficiaries private. You want to maximize your client's control, but again, you're trying to predict the future like you are with any estate planning document, so you want to address a lot of what-ifs. You want to maximize privacy, which is very important. People don't want the government or even the bad guys to be able to look up on the internet and find out where a bunch of guns are stored. And then you want to include as many additional forms as you can to try to serve your clients' future needs. For instance, if they need to remove a trustee, they're going to need that form right away. They don't want to have to set an appointment and come in and see you. NFA corporations are generally like NFA trusts. ATF generally treats them the same way. There's a lot less privacy normally because of the publicly available documents. You can look in the paper or contact me if you want more information about that. This is an example of some of the information you can find about a corporation that's on a free website maintained by the state of Texas, and I've noticed over the years a lot of states have the same type of information available. This is a paid website that the state of Texas maintains where you can actually download the public documents such as the corporate charter and things like that. You can find out who the officers and directors are, what the principal place of business is, and things like that. So that information could be a little bit touchy if you think of a bad guy or some other person out there who's looking this up to try to find out where you store your $25,000 M16. Now let's talk about the new regulation. On January 3rd, the Attorney General signed a new regulation into place. It had been in play for several years before that because they proposed it back in 2013. The end result was significantly different from the one that was originally proposed. And here's a summary of what that new regulation does. Because of the notice requirements, it was published in the Federal Register in January, and it became effective on July 13th of 2016. The number one change that it made is that unlike the past, after July 13th, whenever you send in one of these applications to transfer or make an NFA firearm, you have to disclose who the responsible persons are. This includes submitting fingerprints and photographs of those persons to ATF. The next bullet point is that the CLEO, the local law enforcement officer, has to be notified of the application. And this applies in two different ways. The first one is that the transferee who's going to own the NFA firearms, and that would include the trust if we're talking about an NFA trust, that person has to send a copy of the application to the law enforcement officer, such as a sheriff or a prosecutor, with jurisdiction over the location of the trust. So if you're forming a trust in Smith County, Texas, the Smith County Sheriff is one of the local law enforcement officers, you have to send a copy of the application into the sheriff. The second way this applies is that the responsible persons have to notify their local law enforcement officers. So if I have somebody in Dallas County and another person in Bayer County who are going to be my two other trustees, those persons have to complete a responsible person questionnaire and send a copy of that to their law enforcement officer. Now this replaces the old law, which required individual applicants to obtain CLEO approval of their application. So before July 13th, and this only applied to individual applicants, if I wanted to transfer a suppressor into my name, I had to go get my sheriff to sign the application saying that as far as he knew, possession would be illegal, and I mean it would be legal here, and that he wasn't aware of any unlawful activity that was intended to be accomplished with the NFA firearm. That was a big deal, and that had a lot to do with the original idea of creating NFA Trust, because if you have a trust rather than an individual, that old CLEO signature requirement didn't apply. So if I lived in a county where my sheriff refused to sign these applications, the only way that I could obtain an NFA firearm would be to form a trust or an entity and submit it that way. That bypassed the requirement for local law enforcement to sign off on that. So the new regulation abolished the CLEO signature requirement. That's a major change for the better because it prevents local law enforcement officers from basically banning these items in their jurisdictions. The downside is that you have to provide this information about, you have to provide information to the local law enforcement officer, but that part of it is a good trade-off. It enhances freedom, but it actually also enhances safety by letting ATF know who's going to be in charge of these NFA firearms. The third change is that ATF basically codified their formal policy of letting executors and administrators possess NFA firearms for a reasonable period of time, and now that says during the term of probate. ATF had actually publicly said they were going to do that, and that's the way they handle these things, but now it's actually in the law because it's a part of the regulation. The fourth change is that if a trust or entity has had an application approved in the last 24 months and if their information has not changed, then they don't have to resubmit that information. All they have to do is check off a box and say our information has not changed. I would expect that over time this will make those applications a lot quicker to process because ATF knows that this same applicant with these same responsible persons passed all the background checks and everything and got their application approved. So it should be a matter of just sending it on through. They might conduct a computerized background check to make sure that none of the responsible persons got convicted of a felony or anything during the meantime, but these should be processed a lot quicker. And generally the processing times have been between 6 months and a year, but they've been slowly getting quicker and quicker. And they were down to about 5 months at one point. I don't have any numbers after July. I would expect that the times have gone back up because they have more information to process, but they've been hiring more people and putting more emphasis on getting rid of the backlog. So I would expect those times to drop after they adjust for this. And then finally, this isn't in the regulation. This is something you need to understand. You don't have to get ATF's approval every time you replace a trustee. Rather, you have to notify ATF when you submit an application if any of that information has changed. So, for instance, my trust, if I change a trustee, I don't have to notify anybody. I don't have to get anybody's permission. But if I send in an application after that, then I have to put the new corrected information in the application. So that's one of the biggest misconceptions about this, is that you now have to get ATF's approval to make any changes in your responsible person, and that is not the law.
So Sean, just to clarify that, if you have original trustees and then 6 months later you want to add, you don't have to go through the same rigmarole for the additional 3?
Until you submit your next application, that's correct. You don't have to tell anything to ATF or get their permission for anything. You just change your trustee out like you normally would and get on with your business.
And when would you say the next application? That would be when you buy your next weapon and want to register it to the...
That's correct. There's 3 applications that commonly are used to acquire NFA firearms. One is Form 4, which is a transfer not to a dealer. That form is used to transfer an NFA firearm to an individual, a trust, or a business entity. The second one is Form 5, and Form 5, it's also used to transfer it to a governmental entity, but for a civilian, it's used for a tax-free transfer through probate. So if you inherit one, the executor will transfer the firearm to you using Form 5. And then the third one is the Form 1, which is an application to make a firearm. And make doesn't necessarily mean build from scratch. It also means assembling the components. Like if you take off a 20-inch barrel and put on a 10-inch barrel, you're making a short-barreled rifle. Or if you make a suppressor on your own, that's making one. Or if you assemble a fully automatic sear into an AR-15 and turn it into an M16, you're making a firearm. So those are the 3 forms that are commonly used to either transfer or acquire an NFA firearm.
So Sean, on the standard of practice here, if I draft a gun trust for a client, do I have a duty to also make sure that they fill the forms correctly, or what do you do on that?
Normally the best person to fill out the form is going to be the dealer, because they have to have the item in possession before they can submit the form. And so if you go to buy a suppressor from a gun dealer, the dealer actually has to spend the money to put that item into their inventory, and then that item sits there for about 6 months. So if the form is messed up, then it gets rejected and has to be resubmitted, and that delays them getting paid. So most dealers of NFA items are really good at filling out these forms. They're not rocket science, but there are a lot of little technical things that you have to have in there correct, and it's easy to make a mistake on that. So no, I mean, unless your contract says you're going to help the client complete the forms, I think it would be up to the client and the dealer to get the forms prepared and submitted correctly.
Because if the client already owns the guns or the suppressor, then it's up to the client to submit the form to have it transferred to the trust, correct?
Yes. And there's nothing to prevent a lawyer from helping with that, but my normal practice is to let the dealer do it, because the dealers, I mean, they do those things all day long, every day.
Right, right. Okay, thank you very much.
The other thing I want to mention is that in 2013, ATF also established an electronic filing system, and for a while that significantly sped up the processing of these applications, and they actually cut down on the backlog so there were fewer forms waiting to be processed. The system had a bunch of problems, and as of the last time I checked, it was not available for the most common forms, but they've been working for a couple years now on their version 2.0, and once they have that in place, if it has the same features that the prior system had, you'll be able to pay electronically through pay.gov. You'll be able to pay the transfer tax, and you'll be able to upload your Form 4 as a PDF document, and so you won't have to worry about the mail or anything like that. It'll be a lot more efficient and cut a few steps out of the process. So once they get that done, I would expect the processing times also to drop, assuming everything else stays equal. There's some guidelines in the paper about how to draft an NFA trust, which you can look at on your own. There's a lot of details in there, but in general, what I would suggest you do is you make sure that there's two things that your trust, two features your trust has. Number one is, and this is most important, don't ever instruct your client or the trustees to do something illegal. If you look at the standard living trust forms, the ones that are available straight to the public and the ones that are given to lawyers as part of the form books, a lot of them actually tell you to do things that are illegal if it's a gun trust. One of those is, a common feature is if the settlors die, then distribute the trust property. Well, the problem with that is you have to complete the form and get it approved first. So your trust needs to say that. And that's just one example of a feature that's not legal. It's a standard form there. It makes sense to start using the standard form, but it also makes sense to heavily customize it to meet the legal requirements. That's just one example of things that you need to do when you draft a gun trust. The other thing is, here's a list of some extra documents that you ought to include with a trust. This relates to the fee that you're going to charge for this. My suggestion is that you charge a fee that makes it worth your while to do this, factoring in the risk that you're taking of messing this up and ending up liable for it. Of course, you're not going to have to worry much about that after being through this seminar, but this is a very significant deal, because if you instruct a client to do something illegal and they do it and they go to prison for up to 10 years and end up liable for up to $250,000 fine, you've got some significant exposure there. So I think you need to charge a fee that makes it worth your while to take that risk on, and really worth your while to become competent enough that doesn't become a risk. So along with that, I don't want to nickel and dime a client if I'm charging them a lot of money to do one of these trusts. So I include the forms that are reasonably, you can anticipate them needing, just like I do with an estate planning package. I include DNR forms and durable power of attorney if the client wants it. I think you need, if you're going to be a full-service attorney here and charge a reasonable fee, you're going to be competing with somebody who charges $200 to $300 to do a lawyer-drafted gun trust. You need to deliver more value, and this is one area where you can deliver that value is by including the other documents your client's probably going to need down the road. Question is it still worthwhile to do an NFA trust after the regulation? Because now you don't have to worry about CLIO approval, so you don't have to bypass the law enforcement. You can go buy the NFA Firearm if you want to. My answer is absolutely yes, it is worthwhile. The biggest advantage of an NFA trust is that it protects your spouse and the other persons who live with you and have access to your NFA Firearms from prosecution if you make them trustees. There's a doctrine called constructive possession that basically means if you have access to an item, then you can be considered to have possession of that item, which means if you keep your NFA Firearms in your gun trust, anybody else who has access to that gun trust has at least potentially possession of those firearms. And if they're registered in your name as an individual and not as a trustee, then potentially that could be a federal felony. Forming a trust and making your spouse and the other persons who have access to your gun trust trustees is protection from this risk. It also has an advantage of actually allowing those persons to possess the items. You can loan your suppressor to your uncle to go hog hunting, or you can have your wife bring your short-barreled rifle out to the deer lease without having to worry about getting prosecuted. It also can allow a tax-free transfer by changing trustees as opposed to doing an actual transfer. It allows continuity of control over the firearms over multiple generations, which is one of the big advantages of the estate planning feature of this. People who own guns a lot of times feel like they're family heirlooms and they want to preserve those for future generations. So this allows the settlor to preserve his guns for future generations and pass those on to other family members and loved ones. There also are estate planning benefits in this. And finally, it also allows the attorney and the settlor to keep his friends and relatives and loved ones out of trouble by educating them about the legal requirements for NFA trusts and owning NFA firearms. So there are definitely a lot of benefits to forming gun trusts, especially for NFA trusts, but you have to do it right. You have to be careful for your own benefit and for protection of your clients. So if there are any other questions, you can reach me by email if we don't answer the questions in this seminar. I'd be glad to help any way I can.
Sean, thanks very much. I've got a couple questions here from the viewers. One was, could you briefly discuss the discrepancies between Regulation 41F and Form 5? And what, if anything, responsible persons must submit, and what will the ATF do about this discrepancy?
Okay, Form 5 is a form called tax-free. It's a tax-free transfer form. Form 4 is a tax-paid transfer form. So a retail purchase, you use Form 4 and you have to pay the tax. ATF treats inheritance as a transfer by operation of law rather than a voluntary transfer, and so they don't collect a tax, and they use Form 5 just like they do for a transfer to a governmental entity. If you look at the regulations, there is an explicit requirement for a Form 4 or a Form 1 to identify responsible persons and provide that information. That requirement is not present in the regulation that governs Form 5. However, ATF has included spaces for you to provide responsible person information on Form 5. So it looks like to me they made a mistake and forgot to include that requirement in Form 5, and they just stuck it in the form to try to force everybody to provide that information. Now, if you submit a Form 5 transfer to ATF and don't include responsible person information, what are they going to do? They're going to reject the transfer. So ultimately, somebody's going to have to litigate this by saying that ATF didn't give themselves this authority when they adopted this regulation, or ATF is going to have to amend the regulation and add this to Form 5. But the way things are written right now, I don't believe there's actually a regulatory requirement to provide responsible person information with a Form 5.
Okay. Would residents in states that allow medical or recreational marijuana use be considered to be prohibited persons if they're using medical marijuana or have it present in their home where a gun would be stored?
Well, that goes to the definition of a prohibited person under Title 18 U.S. Code Section 922G, and one of those subsections says that a person who is an illegal user of or addicted to illegal drugs is prohibited from possessing firearms or ammunition. So the first thing to see about that section is that it only applies while that person is a user or while they're addicted to it. So if there's marijuana in the house, you may have a fact issue. The person may get prosecuted, but if it's somebody else's pot and they're not a user, then technically they're not breaking the law by possessing firearms as long as they don't make those firearms accessible to the actual person that's the user. But it certainly is consistent with the position that law enforcement has taken, federal law enforcement, which is that If you use pot, it's still against federal law, and therefore under federal law, you're not allowed to have guns or ammo.
Okay, last question. What are the most common errors you see on gun trusts when you review them? I know we see a lot of egregious issues, but see the most of, so the people who are watching this webinar who review clients' trusts looking for the right problems.
If you use a normal living trust, it's not going to educate the trustees about the gun laws that apply, and it's not going to require them to comply with them. Those requirements are still going to apply, but nobody's going to tell them what those requirements are. So unless they already know what they are, you're putting them at an extreme risk of violating those requirements, which is why I have a very detailed letter that I send to clients when they buy a gun trust that explains all this stuff. That letter actually was where the paper that I wrote that you guys have came from. It's an expanded version of the letter that I give to clients. One of the problems is the termination of trust. That trust can't terminate until all the NFA firearms have been legally transferred out of the trust. Another one is prohibited persons. There's sometimes a trust will not have anything in there that prohibits a prohibited person from becoming a trustee. Well, that means you just gave possession, or at least the right to possess, a machine gun or a suppressor to somebody who's not allowed to have firearms. So there's two crimes right there. Changing the situs of the trust can be a problem, because if you move the trust and the NFA Firearms into another state, you have a whole different set of state laws that apply. You also may have a whole set of different trust laws that apply. So you need to go through an attorney in the new state who can make sure that your trust is modified if necessary so that it works in the new state. And you also need to figure out what the laws are in the new state. And finally, you have to submit a form to ATF if you're going to transfer certain NFA firearms over state lines. And that has to be approved in advance. If you read through, just open up a standard living trust form, or even a Quicken Trust, or one of the ones that you can get at office supply stores, just the really short and sweet forms that they market to consumers. Read through that and keep those 6 principles in mind, and you'll see a whole lot of problems that can come about in trusts. And those trusts are simply not drafted to take those into account.
Okay, Sean, thank you very much. That was an excellent presentation. I always learn something new when I hear you speak. You're a great speaker. Has Sean's email address here. It's Genghis, G-E-N-G-H-I-S, at HealyLaw.com. Let us know any questions, comments, or suggestions you might have. If you're interested in purchasing the book on Amazon, let us know. We can give you the information. Have a fantastic afternoon. And Sean, thanks again.
Thank you, Alan.